Moving from vision to action, the Belt and Road Initiative is set to benefit the infrastructure sector first. As the number of infrastructure projects increases under the initiative, experts predict that the number of legal disputes will also grow. Speaking at the Using Hong Kong as a platform for infrastructure dispute resolution breakout forum at the Belt and Road Summit 2017, dispute resolution expert Paul Starr shared with the audience his experiences in handling infrastructure disputes along the Belt and Road. He considers these disputes inevitable but a manageable risk.
We have 14 offices in mainland China, our office here in Hong Kong, and then offices in Europe and in the Middle East. We're involved, I think, in about 14 disputes along the Belt and Road at the moment. About half of those are international treaty arbitrations. That's where the party who is an investor chooses to sue a particular government rather than going to the sort of domestic form of arbitration. And the other half are the more traditional forms of arbitration. We've got several in London, we've got some in Singapore that is often chosen as a forum, and we've got several in Hong Kong. I don't think you can avoid all disputes on a Belt and Road. There's a lot of politics involved. There are going to be expropriations and nationalisations. What the Belt and Road has done is unify an approach towards dispute resolution that people in government, people who are investing in the project, practitioners and consultants and industry professionals can all use to make it a little bit more unified, the way in which we are going to go about Belt and Road projects. Secondly, the way in which these projects are being drafted, people are going to think, I hope, a lot more about the dispute resolution clauses. It's not just dispute resolution clauses, it's force majeure clauses, repayment clauses, that type of clause, all needs thinking about. My biggest advice is get your lawyers in early. The earlier you get your counsel involved, your external counsel and your internal counsel, the better. In Macau, we just avoided a $700 million arbitration by getting in early, by sitting down with the other side and doing, I suppose, what you might call an informal mediation with the other side. And they've saved all that money, both parties, on going to arbitration. All the bitterness, they're still working together. They preserve business relationships. That's terribly important.